Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a point whether directing the accused to drop his Google Pin location or to tell his location at every time, is it violation of right to privacy or not? Right? Honorable Justices Abhay S. Voka and Pankaj Mittal, in the case of, while dealing with the case of Enforcement Directorate versus, his name is Raman Bhuraria, he is a chartered accountant of SBFL company. Raman Bhuraria, in diary number 23447 by 2023, held that prima facie asking an accused person to drop his PIN location or to drop his Google PIN location is a violation of the right to privacy. It's fundamentally, basically, but we all know, according to the constitution, there may be reasonable restrictions. Right? So, normally, in the case of 438 or 439 CRPC, that is anticipatory bail, we will be seeing the orders by the court that the accused should report before the police station every Sunday between 10 and 11 a.m. once in a month. Like that, they will be putting conditions. Are they violation of the right to privacy, Article 21 or not? So previously we used to think that they are reasonable restrictions. Now they will also change from case to case. Now let us know the facts of the case. Please remember, Supreme Court yesterday, that is on that is on 3/10/2023, orally remarked that imposing a bail condition requiring an accused to drop his Google PIN location from his mobile phone to the IO, that is to the investigating officer, concerned throughout the period of his bail is prima facie violative of his right to privacy. This is what is stated by Abhay Voka and Justice Pankaj Mittal. Right? Now, please remember, the facts of the case are like this. An FIR was registered regarding financial irregularities and siphoning of funds in relation to the credit facilities obtained by SBFL company from a consortium of banks led by the State Bank of India and which caused loss to a tune of rupees 3,269.42. So this SBFL company, they have taken loans about 3,000 crores, but they have siphoned off. They have committed the so-called breach of trust, and for which our friend Raman Bhuraria, he is the chartered accountant. No doubt, when he filed the bail petition, anticipatory bail, he stated that his name was not figured in the FIR. His name was not there as an accused in the FIR, and during the period under inquiry, he was not the internal auditor to the SBFL company. Prior to that, he was the auditor. But when the case was registered and when the inquiry was going on, he was not the auditor. See how technically he wanted to avoid the clutches of the law. Now in Andhra Pradesh also, some almost similar cases are going on. Whatever it is, now when he approached the bail, so 2 points he said. Number one, his name is not there in the FIR. But you all know, FIR is not sacrosanct. So if some persons are named the FIR, they only have to be charged. There is no rule. During the course of investigation, so many persons can be lugged in. Number two, he was not the auditor to the company at the particular point of time. Okay, that is for the investigating agency to verify. So when he has applied for bail, the Delhi High Court granted the bail. So holding that CBI or enforcement directorate, they can proceed the investigation. But bail was given to the applicant on the following grounds. So that he shall furnish a security for 50,000 with two sureties. This is quite common. Second point, the applicant shall furnish the IO and SHO his cell phone number. He has to furnish the cell phone number on which he can be contacted at any point of time by the IO. Right? And third point, more important, the applicant shall drop his Google Pin location from his mobile phone to the IO concerned, which can be kept operational throughout his bail. So this is the main point. Whether this can be taken as a violation of right to privacy or not. So notices were given to the other party, and actually enforcement directorate filed a petition against Raman Bhuraria to cancel his bail. But now the point has come. So the arguments are like this. So suppose on behalf of the so-called CBI or the enforcement, they say that yes, previously, just now I told you, previously the court used to direct them to appear before the IO on so-and-so dates. So that is at the time when the mobile phones were not there. Since mobile phone is there, instead of going there, he can drop his location and it can be checked by the IO. So what is the difficulty there? So that is the argument. But other side is, it is violating his right to privacy. When the court has given bail, what is the purpose of asking his Google location? So anyway, matter of controversy. Let us hope what will happen, and if any good result comes, I will inform you certainly. So these are the rights relating to life and liberty. These are the rights, human rights, and you have to fight for them if there is any violation. For that purpose only I am making this video. Otherwise, I will easily say that it is only a reasonable restriction. You cannot fight in the court of law. It's not correct. You have to think. You have to analyze. For that purpose only I am making this video. Please read the diary entry or part of the particular case law. Definitely you will know the points relating to the human rights. With this I am concluding. Thank you very much.